Okay, here we go. County Court at Law number 2, Jefferson County, Texas, is now in session for its arraignment docket. We have present Mr. Pierre Otis Williams, Senior.
Senior, yes, sir.
Mr. Williams, how are you doing?
I'm doing fine.
That's good. Now, Mr. Williams, you were asked to come here this morning for what is called an arraignment. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and your options or concerning your case. Now, the case that you have here is a misdemeanor case. Cases are divided into felonies and misdemeanors. Your felonies are normally referred to as your most serious type cases, and your misdemeanors are normally referred to as your petty offenses. It does not mean that they are not serious. It just means that they are not as serious as your felony offenses. Now, if you had a felony offense, it could either be a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. State jail felony is the lowest felony that you can have. For a state jail felony, the range of punishment is anywhere from 6 months to 2 years in the state jail, fine up to $10,000. For a third-degree felony, range of punishment is 2 to 10 years, fine up to $10,000. For a second-degree felony, range of punishment is 2 to 20 years, fine up to $10,000. For a first-degree felony, range of punishment is 5 to 99 years to life, fine up to $10,000. And the highest felony that you can have is a capital murder. And if you are convicted, the range of punishment is anywhere from life to death. Now, your offense is classified as a misdemeanor offense. Misdemeanor offenses are divided into 3 categories, class A, B, and C. Your class C misdemeanors are those offenses in the JP court, which is justice court, or the city court, the municipal court. They are fine only. You only can get a fine. You cannot get jail time for a class C misdemeanor. Now, you have the highest misdemeanor is a class A misdemeanor, and the range of punishment for class A misdemeanor is anywhere from 0 days to 365 days in the county jail, a fine from $0 all the way up to $4,000 or anywhere in between. Now, the offense that you have, which is a class B misdemeanor, the range of punishment is 0 days all the way up to 180 days or anywhere in between, a fine from $0 to $2,000 or anywhere in between. Now, you may qualify for probation. There are 2 types of probations. One type of probation is called unadjudicated probation. We normally refer to that as deferred adjudicated probation. The other type of probation is called adjudicated probation, and we refer to that as regular probation. Now, if you are given a deferred adjudicated probation, it does not result in a conviction in record, and you may qualify for non-disclosure. And what a non-disclosure is, it means that we cannot disclose to the public that you were on probation for this offense. And if you successfully complete the probationary period, this case will be dismissed. It will not result in a conviction on record, and you may qualify for a non-disclosure. However, if you violate any terms and conditions of probation, the state can file a motion to revoke your probation. And if your probation is revoked after a hearing by the court, if it is found to be true that you have violated any one of the conditions of your probation, then your probation can be revoked. And if your probation is revoked, you can be given a conviction. If you're given a conviction, obviously, the case is not going to be dismissed and you cannot qualify for a non-disclosure. Now, regular probation, on the other hand, does result in a conviction in the record. However, there's something that is called judicial clemency. Judicial clemency means that the court can set aside your conviction. In essence, you will no longer have a conviction. And the way that works is you have to successfully complete the probation. There cannot be any more time left on the probation. It has to expire. And then the court has to discharge you, which means let you off of the probation. And if those 3 things happen, then the court can allow you to come back in the court to withdraw your plea of either guilty or no contest. And if that happens, any complaint, affidavit, or information that has been filed against you can be dismissed. And if it's dismissed, you can truthfully say that you weren't convicted of this charge. Why? Because you was given judicial clemency. However, If you get a subsequent, which means another conviction later on, then this case can be revived, resurrected, or brought back up, and it can be used against you. All right. And the other thing, if you try to get a license with CPS, they could deny giving you a license, or if you have a license, they could suspend or revoke the license that you have with CPS. Now, as a defendant in a criminal case, you have rights. One of the rights that you have a right to have a trial by jury. And where those young people are sitting in that area over there with those 12 chairs, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on the case, and they'll decide whether or not you're guilty, innocent after listening to all the evidence in your case. Now, you have a right to waive, which means you have to waive your right to jury, which means you have a right to give up your right to a jury trial. And by doing that, then you will not have a jury trial. However, your case will come before the court, come before the judge. It can come before the judge in one of 2 ways. One way is by way of a trial. We call that a bench trial. It's a trial before a judge only. And that simply means that the judge will listen to the evidence, and at the end of the evidence, the judge will decide whether or not you're guilty or innocent. And if you are found guilty, the judge will also assess your punishment. Now, the other way your case will come before the court is by way of a plea. Now, when I say a plea, a person has a right to enter 1 of 3 pleas. They can enter a plea of not guilty, guilty, and no contest. Now, if you enter a plea of guilty and no contest, the case comes before the judge by way of a plea. Now, you have 2 types of pleas. One type of plea is where you have an agreement with the state of Texas. In essence, y'all reached a settlement on your case. For example, let's say you spent 5 days in jail, and the state is offering you 5 days in jail, and you accepted that. That's a plea bargain agreement. Now, let's say you spent 5 days in jail, and the state is offering 50 days in jail, and you did not accept that. But you still want your case to come before the court. We call that an unagreed plea. In essence, y'all haven't been able to reach a plea bargain agreement, but you want the judge to assess the punishment in your case. All right. So your case will come before the judge in a plea in 1 or 2 ways, by either agreed plea bargain or an unagreed plea. Now, you also have a right to have witnesses to come to court. That chair over there, we call that the witness stand. And what witnesses do, they can testify for you, against you. You can ask them questions if you represent yourself, or if your attorney is representing you, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. And by doing so, if you waive your right to have witnesses to come to court, you will not be calling any witnesses. However, the state will be calling witnesses in their case that they have against you. You also have a right to have what we call, in terms of testifying, you have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your own case. You may have heard it referred to as taking the fifth. In essence, a person to say, well, I'll take the fifth. That means I don't want to testify because I'm invoking my Fifth Amendment right against self-incrimination. Now, you also have a right to waive or give up that right as well. And by waiving your right against self-incrimination, that simply means that you will be testifying in your case. You also have a right to have what we call discovery. Discovery is you have a right to see the evidence that the state has against you. You have a right to see the documents, the witness statements, the videos, etc. Whatever, or physical evidence, whatever evidence that they have in your case, you have a right to have access to it. Now, if you're represented by an attorney, your attorney will have access to the evidence that the state has in your case. Now, you also have a right to waive or give up your right to have discovery, which means you have a right not to have access to the evidence that's in your case if you choose to do that, or choose to exercise, or choose to waive your right to discovery. Now, the state has a program that is called pretrial diversion. And what pretrial diversion is, let me do this here. Before I get to pretrial diversion, The our court coordinator, our court administrator rather, handed out a clipboard to you that had some information on it. And it also has another right that you have. You have a right to have an attorney. And on this document that reads judge's explanation of rights to defendants without an attorney, I'll go over it, which it says, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it reads, defendant's choice. Mark initials next to only one choice. Now, if your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you have already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you have already been appointed a court-appointed counsel, then you put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, then you will sign the document where it says defendant, and you'll place today's date on that document, February 8th of 2022. Now, if you have selected or put your initials on line number 5, stating that you want to waive your right to an attorney and represent yourself, then you would have to fill out the next page that's titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 8th day of February of 2022 by the county court at law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel. I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you'll sign on the line that says defendant and you place today's date, February 8th of 2022. Now, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. On that program, if you are able to get into that program, then your case will be dismissed, and it will be, you could get it expunged from your record. And simply, the way it operates is as follows. You have to get an attorney to assist you to get in the program. You cannot have an offense that's involving DWI, unlawfully, you can't have an offense of unlawfully carrying a weapon or resisting arrest. Those are the 2 offenses that's prohibited for that program by the district attorney's office. And you cannot have a criminal record, and you have to have an attorney to assist you to get into the program. Now, if you're all able to get into the program, the case is dismissed, you complete the program, then you qualify for a expunction, which means expunction means erased, deleted, or wiped off from your criminal history. If you are a veteran of any one of the branches of the United States military, Jefferson County has a program as part of its pretrial diversion program. That program is called Veterans Court. The only thing you have to do is to be a veteran to get in the program. If you get into the program, case is dismissed. You complete the program, you can get it expunged from your record. This court has a program that is called Community Safety Initiative, stands for CSI. But the CSI program is designed to address the issue of recidivism. Recidivism is where people commit crimes over and over. And so to address that, we have the Community Safety Initiative. And the way the program works, we have partnerships with local agencies. We have a partnership with Spindletop Center, our local mental health agency in this region. And Spindletop, they're able to do private interviews, assessments, and they can develop a treatment plan, either outpatient or inpatient, for individuals who have mental health issues. And your mental health issues, it does not have to be to the point that you're incompetent or insane. But if a person has, they suffer from depression, it could be bipolar, schizophrenic, or it could be a person could be suffering from anxiety, post-traumatic stress, or a whole host of other mental health issues, then Spindletop will be able to address those issues. Now, if an individual has a problem with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And with that program, Spindletop, for individuals who are 21 years old or younger, Spindletop can do a screening, interviews, develop a treatment plan, either outpatient or inpatient, to address any drug or alcohol issues that an individual may have. Now, if individuals who are 21 years, say, are older than 21, then OZAR, which is the outreach screening and assessment referral, they can do screenings, they can do assessments, and they can develop a treatment plan, either outpatient or inpatient. They can refer you to a facility to address your drug or alcohol issues. If you are unemployed or do have a low paying job, if you want to get a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those fields, they will assist you at getting a job in the area that you are trained in. Now, if you have not received your high school diploma, they also have a program, CICE does, they have a program to help you to get your GED so that you'll be able to gain employment. And this program is designed to address the issues, the cycle that exists, and the cycle that I'm speaking of, people who normally, when you don't have an education, you can't get a job, you normally may get depressed, you turn to drugs and alcohol. Once you turn to drugs and alcohol, you may eventually commit a crime, and once you eventually commit a crime, you'll get caught and you'll do time. And once you do time, you're going to get out and you'll be back in that cycle. And so in order to address that cycle, we have our Community Safety Initiative, which is a CSI program. And I tell people this all the time: when you come to County Court at Law Number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in Jefferson County. With our programs in County Court at Law Number 2, we do not just give time, we take our time. And we take our time by not arresting the problem, but addressing the problem. And so if you're interested in any one of the programs, just let the court know, and we'll be happy to assist you at getting in any one of the programs that address the needs that you have. This program is also designed to make productive people. We believe that making productive people productive people do not commit crimes, and because they do not commit crimes, we can make Jefferson County a safer place for all of us to work, live, raise our families, and go to church. So at this time, we have we have Jess from Spindletop, and Jess is going to come forward and tell you something about the program that they have at Spindletop. Jess?
Well, you done, so we can just talk to them individually.
Okay, that's fine. Okay, so what we're gonna do, Spindletop is gonna talk to you individually, see if you have any issues or any concerns that they can help you with. So at this time, the court will be in